The courtroom rises as the judge enters. The Thornton case is called. What sounds routine quickly reveals deeper conflict. This is a return to court, and expectations are high.
All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Mr. Thornton steps forward. He doesn't look confident. He admits things are not going well. He's here because life with his son has taken a sudden and serious turn.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And
Mr. Thornton explains the change. He now has full custody of his son, AJ. The mother is not present. AJ is living with him, and what follows is troubling. The child is in serious legal trouble.
I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to
The details spill out. Burglaries. A police chase. A serious accident. Medical bills pile up. Insurance refuses to pay because the injuries stem from criminal activity. The financial pressure is crushing.
police chase.
This is AJ, right?
Yes.
Okay.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean,
Mr. Thornton turns his focus to the child's mother. He says she has moved out of state. She quit her job. Her insurance no longer covers their son. He feels abandoned and overwhelmed.
medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
If I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him
Okay.
in that aspect. And
The judge brings the courtroom back to the agreement. During mediation, both parents agreed to no child support. AJ lived with Mr. Thornton then, just as he does now. That fact matters.
the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay, here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support.
The judge explains the law clearly and firmly. To change child support, there must be a material and substantial change. A move. A shift in custody. A change in income. Trouble alone does not qualify.
There has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just free of any obligation? I mean...
Well, I wouldn't say she's necessarily free.
Mr. Thornton is visibly disappointed. He asks if the mother has no obligation at all. The judge clarifies. It's not about fairness. It's about what the law allows based on evidence and agreements already made.
But remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely.
As far as I'm concerned,
the conclusion is unavoidable. Nothing legally significant has changed since mediation. The court cannot order child support. The judge acknowledges the hardship, but her authority has limits.
no, there's nothing you can do. Yeah.
All right. Thank you.
Okay,
Your
is
Honor.
there anything further?
No, ma'am. Not at this time.
Okay,
That's about it.
okay. Well, if there's nothing further, you're dismissed.
Thank you.
You're welcome.
As the case closes, the judge explains the ruling for the record. Agreements matter. Evidence matters. And without a true legal change, the court cannot rewrite the past. Her final message is firm and measured. The law may not always feel fair, but this court can only rule on what has truly changed.